So many of us predicted long ago that once Elaine's role in this case was done, it would be under the tires of the bus with her. And I think what we see from this statement is indication that that is very likely to be the case. So a question that a lot of people have had in light of that is, does that give Amber an advantage on appeal? Is she throwing Elaine under the bus so that she can blame Elaine for the outcome? She made mistakes. She did things wrong. She was a terrible lawyer. It wasn't fair. I didn't have good representation. Therefore, I should get a new trial. And so the answer for that is very simply no. Ineffective assistance of counsel is not a basis for appeal in civil actions. The whole idea of ineffective assistance of counsel comes out of criminal law. But criminal cases are a little bit different because we have a Sixth Amendment right to counsel that specifically applies to criminal prosecutions. And so, as a result of the Sixth Amendment, the U.S. Supreme Court has held that in a criminal case where a person's life or liberty is at stake, they don't have a realistic prospect of being able to defend themselves when they are up against a seasoned lawyer representing the state. So in those types of circumstances, it's simply you're so outmatched that it's not going to be a fair process. And so that's why the founders specifically created that right to counsel in the Sixth Amendment for criminal cases where those fundamental interests of don't put me to death, don't lock me in a cage are at stake. That rule was first recognized back in the 1930s. It subsequently was applied to the states in this landmark case known as Gideon versus Wainwright. It's still the same principle. The Sixth Amendment gives special protection to criminal defendants when it comes to their attorneys. And so as a result, not only do you have the right to have an attorney appointed, you have the right to a competent attorney. So this is very distinct from the situation in civil cases where in some circumstances there might be a statutory basis for giving you an attorney. But by and large, there is no constitutional right to an attorney in a civil case, with a few limited exceptions for situations where similarly fundamental rights are at stake. And examples of those are situations where the state wants to put you in a psychiatric hospital against your will. The state wants to strip you of your rights to parent your children. These are situations where, although the proceedings are technically civil, because they involve important human rights, these are situations where there has been recognized to be constitutional interest in evening the playing field by requiring that counsel be appointed to the defendant. But in your average run-of-the-mill civil case, you don't have that right. And case law has made this very clear. I have chosen for an example here this case out of the Eighth Circuit Court of Appeals. So this arose from what's called a 1983 lawsuit. This is a specifically statutorily authorized claim for people to sue the government, essentially, for depriving you of your civil rights. So this is often used in situations where there's been an unlawful arrest, there has been excessive use of force, those types of claims against the government. And that statute specifically provides for circumstances where the district court can appoint counsel to represent somebody, but it's not required. And so in this particular case, counsel had been appointed, but the defendant, or in this case, the plaintiff, was unhappy with how the attorney was performing, didn't like the job he was doing, basically, and so had asked for a new attorney to be appointed. And the court in that case made it very crystal clear, no, that's not the standard in civil cases. You don't have the same type of constitutional protection for your right to counsel that you have in criminal cases, because of the Sixth Amendment being the source of that criminal protection. So essentially, in a civil case, your right to counsel is that you have the right to hire one. They can't close the courthouse door on your attorney. If you want to be represented by an attorney, you can't be prevented from doing that. But that's pretty much where the line is drawn. You get to choose your lawyer. And so there are upsides and downsides to that. In Amber Heard's case, she wanted a particular skill set. Perhaps in retrospect, there were downsides to that maybe she wishes she didn't take on. But that was her choice. She was free throughout the process to replace Elaine, to discharge her. As we have seen, Elaine would have no choice but to withdraw if Amber fired her. And she chose not to do that. So ultimately, the consequences of that are on her. The remedy for being unhappy with your attorney in a civil case, their underperformance, negligence, whatever, is to go sue them for malpractice if you think you can make that showing. But that is not going to disturb the verdict in the underlying case that the attorney allegedly messed up. So we have this colloquial expression when we talk about withdrawals, distinguishing between a quiet withdrawal and a noisy withdrawal. Now, 99% of the time, if not more, the only responsible, ethical way to withdraw from representation is quietly. And the reason why is quite simple. You have duties of loyalty and confidentiality to your client. You must continue to maintain those even when the relationship is severed. So, as much as you might like to rant and rave about what a nightmare it was to represent this particular client and tell the world about all of the difficult things that they did behind the scene and just what an awful experience it was, you don't get to do that. Those are part and parcel of the responsibility of being an attorney, that you cope with those in your own way and you keep it to yourself. So a lot of times when you see attorney-client relationship breakdown that goes real bad, that can lead to like ethical problems, things like that, it's often in the context of a noisy withdrawal, meaning the attorney says a little bit too much about why they are getting out of this particular case. So I do find it really telling here that Elaine, she actually pulled off a move here that is far more subtle than I think I would have given her credit for. So kudos to you, Elaine. She has managed to pull off the quiet withdrawal that nevertheless speaks quite loudly. And I refer, of course, to this choice of language, this pledge that she has given to Amber Heard. You know, there's a lot of words you could choose to use in this communication. Pledged is not a word that I think is commonly chosen for this type of situation. You might say, I commit to, I undertake to, I promise to. Pledge, though, pledge, just like Amber Heard pledged. Oh, it just brings back all of those credibility problems that Amber Heard has had with her case for so long. Is Elaine telling us, You know, she knew all along because we know you knew, Elaine. We know you knew.